Imagine waking up one morning and realizing that something you've done inside your own home for decades is suddenly grounds for fines, legal action, or even forced compliance. No criminal charge, no police knock, just a letter from your homeowners association telling you that smoking inside your own house is no longer allowed, and if you don't comply, the consequences could ripple far beyond a warning. That is not a hypothetical. This is already happening, and in 2026, it is accelerating. Across the country, homeowners associations are moving past banning smoking in common areas and are now pushing restrictions inside private residences. The justification is familiar: health concerns, secondhand smoke, property damage, and the claim that smoke drifting through walls or ventilation systems interferes with neighbors' ability to enjoy their homes. Courts have increasingly agreed, especially in condominiums and townhomes where air systems and walls are shared. Supporters argue this is about safety, not control. They point to studies linking secondhand smoke to health risks and to cases where smoke residue damages walls, flooring, and HVAC systems. They say associations have a duty to protect residents and preserve property values. From their perspective, allowing smoking inside one unit can reduce the value of surrounding units and increase maintenance costs for everyone. But critics see something very different unfolding. They see a steady erosion of private property rights through contractual fine print and vague nuisance clauses that can be expanded after the fact. Many homeowners bought their properties long before these rules existed, never imagining that activities inside their own living rooms could later be regulated by a board vote. What feels like a personal lifestyle choice suddenly becomes a compliance issue. Florida and California are at the center of this shift. In Florida, proposed legislation would expand smoking and vaping bans in multi-unit buildings and potentially even public spaces. In California, a new disclosure law now requires sellers to reveal any known history of smoking or nicotine residue in a home. That alone signals how the legal system now views smoking, not as a habit, but as a material defect that can affect value and habitability. Some cities have gone further, classifying smoking in multi-unit housing as a public nuisance. That designation opens the door for neighbors to sue each other directly, with fines that can start at hundreds of dollars per incident. Once that line is crossed, disputes that used to be resolved through conversation can quickly turn into legal battles. This is where insurance quietly enters the picture, and most homeowners do not see it coming. When smoke damage becomes a known issue, insurers take notice. Claims related to smoke residue, odor remediation, and HVAC contamination can increase loss ratios for multi-unit buildings. As those claims rise, carriers respond the only way they know how, by increasing premiums, tightening underwriting guidelines, or excluding certain types of damage altogether. Even residents who do not smoke may end up paying more, simply because their building is now considered higher risk. There is also liability exposure. If smoke is classified as a nuisance or safety hazard, claims between neighbors can escalate into personal liability disputes. Destiny costs alone can be significant, and not all policies respond the way homeowners expect. Many policies were not written with these emerging conflicts in mind, leaving gaps that only appear once a claim is denied. Associations face their own insurance challenges. Enforcement actions, fines, and selective rule application can trigger claims against HOA boards themselves. Directors and officers coverage becomes critical, and premiums in that area are already rising as disputes become more common and more expensive. Proponents counter that bans reduce long-term costs. They argue fewer smoke-related repairs mean fewer claims and more stable insurance pricing over time. They say prevention now avoids higher costs later. Opponents respond that shifting enforcement into private homes creates friction, lawsuits, and administrative expenses that ultimately get passed right back to residents. Caught in the middle are homeowners trying to understand their rights. In some cases, existing smokers are grandfathered in. In others, medical marijuana use raises accommodation questions under fair housing laws. And in many associations, boards amend rules with slim margins, leaving residents feeling blindsided. What is clear is that this trend is not slowing down. As courts increasingly side with health and nuisance arguments, and as insurers adjust to rising claims, the cost of these policies will not stay contained. Whether you smoke or not may soon be irrelevant. The financial impact spreads across the entire community. This is no longer just about smoke. It is about control, contracts, liability, and who ultimately pays when private behavior becomes a shared risk. For homeowners, the lesson is simple but uncomfortable. Read the documents. Watch the amendments. Understand how insurance responds, because once a rule changes, the consequences do not stop at a fine. They show up in premiums, claims, and the very definition of what it means to own your own home.